Joining us in the hot seat this morning for our Justice Thursday conversation is constitutional and governance expert Steve Ogolla, gracing the hot seat this morning as we look into issues around balancing and constitutional rights and public order. So that conversation takes place this hour and Steve Ogolla is here. Steve, good morning.
Good morning.
How are you?
Very fine. I'm happy to join you.
Fantastic. Well, it's good to have you here.
Yeah, thank you.
First time in the hot seat.
Yeah, I think so.
Yeah.
Very excited. I've been looking forward to this.
And here we are today.
Yes, sir, thank you.
The things that we look forward to sometimes come to pass. What we normally do is that we go to different African countries every week. This week we're in Rwanda, and we're going to share some of the proverbs that the particular country has come up with. Dennis is going to tell you the proverb, and then you let us know what your interpretation is, because we know you are in the business of interpretation. So this shouldn't be too difficult.
Yeah, and in the country of Rwanda, one of the things that stand out is it is one of the least corrupt countries in Africa, and they have a monthly cleanup that happens every month where individuals come in to just clean their country, the reason why it is considered one of the cleanest countries in the world. And the proverb today, the road does not tell the traveler anything. The road does not tell the traveler anything. What would you make of that?
Sorry, I was still trying to put my thoughts together.
Maybe you can
talking when I was taking my notes, but I can take that again.
The road
does not tell the traveler anything.
Your interpretation of that proverb.
Well, you have to discover what the future holds. Yeah.
Short and simple.
Okay. Sometimes it doesn't need to be complicated, does it?
You don't have to complicate it.
You can just actually hear it and then you go from there. We're looking into balancing constitutional rights and public order. And of course, we keep saying that the past couple of weeks have constantly served up for us situations into which we would need some kind of explanation, interpretation, then what happens with the law and all of this. So I think it's pretty apt that our Justice Thursday conversation today is right around this, because when it comes to public order, there are two sides, and let's start by trying to decipher this. There are two sides. One that says that public order must be maintained, it must be observed, it must be adhered to, it must be maintained, and that there are institutions and agencies who are given the mandate to make sure that that is upheld. That's on this side. There's also the other side where saying that public order must be maintained, true, but human rights must be upheld in spite of the necessity of the maintenance of this public order, because there's this almighty law called the Constitution that we are bound by within the boundaries of this nation, whether it's written down or not. There is the Constitution, and that is the supreme law. So here we are with the events that we see unfurling day after day after day. Where is the space where the two meet, whereby we say there's the demand and the rule of law, but there's also the place where we are saying that people under who have their constitutionally given right then must be protected? Where do we meet?
Well, first of all, permit me, since we're having this conversation in the context of the most recent protests and the killing of Albert Ojwang, I think the first thing to do is to pass my sincere and heartfelt condolences to the family of Albert Ojwang, and also to wish a speedy recovery to Boniface Mwangi Karaoke, I believe, who was shot almost fatally. We thank God that he survived. And we hope to see accountability to that effect shortly. Now, the Constitution identifies the recognition, protection, and promotion of fundamental rights and freedoms, broadly known as just human rights, at the center of its design. So nothing is more elevated and more pronounced than the protection and promotion of fundamental rights and freedoms. So considerations on balancing rights and freedoms as against public order must be understood in the context that conversations on public order play subservience to the protection of fundamental rights and freedoms. If you contradistinguish the system that we have now under this new constitution as against what we had in pre-2010, any statutory provision like the Public Order Act or any legislation that seeks to control the manner in which the citizens exercise their rights under the Constitution must be read in the context of the history we've come from. Because in pre-2010 Constitution, what many scholars have characterized as an almost near autocratic regime or an illiberal democracy, you had rights, for instance, the freedom of speech, but not the freedom after speech. The right to vote, but not the right to make your vote count. The freedom of assembly, but subject to permission by the state agencies. So in the new dispensation, the volume of speech is not limited. And the amount of the amount of exercise of that right, whether how many times you can appear on the streets to exercise your freedom of expression and association, is not limited. And the reason why we talk about public order, it's only for purposes of facilitation of the enjoyment of those rights. So that is the context in which we must discuss public order. Public order, in short, is supposed to facilitate, not inhibit, enjoyment of fundamental rights and freedoms. If we can share that thought, or if you have a shared and settled understanding of the purpose of public order in the context of the new constitutional dispensation, then there will be no need for a clash or for any unhealthy tension. So in short, public order is necessary so that those who want to protest can do so, while those who want to go about their businesses can also do so. But it's not supposed to be used to curtail or unnecessarily limit freedom of expression or freedom of assembly and association.
Wakili, what about designation?
Yes.
Because there are these freedoms, there are these rights that will not curtail one or the other.
Yes.
So you have the people who want to run the businesses, but also you have people who want to protest, and both enjoy those rights. But when now you have a state coming in and saying, okay, you know what, let's divorce this matter from now the politics and what currently is going on, how the chaos were planned, the hiring of goons and police brutality. But in essence, when now the same state comes in and says, we will allow you to exercise your rights, but we will designate you to specific areas and limit you to specific areas, how does that then tie in to what you've just said?
Well, designation to what you may consider as protest zones is not necessarily unlawful or contra constitution, but it must not also be used in a manner that is intended to undermine the overarching principle that makes people protest. The whole idea of protest is to force government to act one way or another.
Yes.
So if you tell protesters to go and protest in Kitengela, or maybe in the peripheries of the CBD, where that protest has no effect, then I think you would be applying those guidelines in a manner that contravenes the freedom of assembly and association. But as the administration, be it county or national government, if you say, look, the people who run businesses in the CBD also have a legitimate interest to be able to access the CBDs, so we can all agree on the frequency of protests within the CBD. Honestly, okay, it cannot be that protests in the CBD are a daily affair, because then that it would then change the character of the protest from driving a constitutional agenda, not a political agenda, a constitutional and lawful agenda of expressing dissatisfaction with the state of affairs and or governance in the country, to a more clandestine and disclosed agenda of disruption. So it calls for balance. Balance, we don't need to stretch our minds on what constitutes a perfect balance. A perfect balance will be seen on case-by-case basis. So in short, protesters have a right to access the CBD, right? And law enforcement agencies have a duty to provide security. Right?
Yes.
So far, the protests, as I see them, I think they are organized. If they are organized weekly or maybe monthly, I think that would be consistent with the principles undergirding freedom of expression and assembly. I have not seen protests daily. If they were to be conducted daily, then, that would disrupt the works of other people who want to go about their businesses. So right now, we shouldn't be asking how to designate, but the law on designation previously has been abused because we have seen instances where the OCS or the IGP, through the relevant regional commander, operations commander, outlawing protests in the CBD. The Constitution says or requires that you must justify your action as having been founded in the law. So there's need for a compelling rationale to say you cannot access the CBD for purpose of protest. So that rationale, if people disagree with it, then the solution is, if you look at Article 24 of the Constitution, then the state agency that wants to lock people from accessing the CBD, then they must approach the High Court and give the High Court reasons why they think frequent protests in the CBD must now be limited. And then the High Court will balance both sides and will give an interpretation.
Okay.
But,
Sorry, do the but.
Yeah, but as a rule of thumb, protesters have a right to protest anywhere, provided they notify the police to provide security. It is only when the law enforcement agencies feel that they are too frequent and they cause unnecessary disruptions that they can then provide guidelines that move people from the CBD.
Okay. I didn't think I'd ever say it, but it would appear as though the law is very clear.
Yes.
That very clearly what security agencies are supposed to do in a position of protest, that we know that the Constitution has granted the rights to Kenyans, because that's the jurisdiction under which this is operational, has granted the right to Kenyans to then be able to protest anywhere, anytime, like that.
Yes.
The information that is now given to security agencies is for their own protection. So like in the case that we saw the other day, should be for their protection from external parties like the goons that we saw.
Yes.
Or unfortunately, in some cases, like the police themselves. We should have seen a situation where, for example, that day when Boniface was shot in the face, in the head, that there should have been other police people or policemen, women, rushing to that point for his protection, for his rescue. This is what we are saying essentially should have happened.
Yes.
But we say this all the time. And so it pushes me to the place where I start to really, really believe those who say sometimes in jest that the Constitution is there for convenience, that when it is suiting your needs, then you quote it. But when it doesn't really help you, then it's a suggestion that we put into the corner. And unfortunately, that has been the practice for too long a time for anybody to say, why do we have a constitution if we're not going to be abiding by the tenets of it? Why is it there?
Yeah, I think the reason why that question keeps recurring is because just like this conversation, we start this conversation from the middle. The law says, the law requires a very prescriptive approach to very important national conversations. If you reflect on the organizing principle or the organizing question why people get out or why people agitate, then you'd have to begin that conversation from the start. And from the start now is, look, the Constitution has inbuilt or internal railguards that protect itself from destruction of its democratic ideals or safeguards. Yeah. So some of these guardrails are what manifests outside there in the form of the first one is, for instance, public and state officers now must be held accountable for their own actions. Like in the context of this protest, if you look at Article 245 of the Constitution, the Inspector General of Police bears the final responsibility for the actions of the officers under his command, and the Constitution says he is not susceptible to, or should not be susceptible or amenable to external authority or direction. Now, number two, the legislative wing of government, the political wing of government, Parliament, the National Assembly, and the Senate, they are required to enact laws. So if they do these things sequentially, we won't be having the kind of problems you are raising. They're supposed to enact laws that amplify protection of rights and good governance. Number three, you have the judiciary that is already clothed with countervailing powers. The power of judicial review, the power to look at decisions taken by the National Assembly and the executive and pronounce themselves. If that operates at an optimum, then we would not be probably getting in the streets. Number four, you have constitutional commissions and independent officers who perform key constitutional roles. If we were taking their reports and their mandates seriously, there probably would be no need for spillovers. Now we are at the fifth limb, which is the civil society that demands public vigilance. The civil society does not mean the NGOs or human rights groups like Atiba Institute and so on and so forth. The media, trade unionists like KPMDU, NAT, KOTU, active citizens like Boniface Mwangi, all these form an important clog of accountability that drive the momentum towards good governance. This is the last limb. We should not be although the freedom of assembly and association is guaranteed by the Constitution, the right to protest is guaranteed, we shouldn't be looking to protest as a way of driving our governance agenda.
How do you do it? And I
If
think
the first four limbs were operating at an optimum, and remember I've left out the executive deliberately because the executive is the one that exercises state authority. So in this accountability framework, you have four important players, and then you have the public or the civil society. If the first four limbs or pillars that undergird the Constitution were operating at an optimum and perfectly, we would not need to worry about people pouring into the streets. Because, for instance, So if we start this conversation, how come the law provides for protests and they don't get it? It's because somewhere in between there's a broken safeguard or a broken railguard. Because if Parliament, for instance, and we've seen them attempting in this case, to summon the IG and all that and the CS, but if Parliament was able to operate as independently as the Constitution has conceptualized it to be, then we would trust the National Assembly and the Senate to hold other state organs to account, and there will be no need for protest. Because you're not protesting just because you can. I think these protests sometimes are a reflection of the failures of the institutions that are created by the Constitution to perform at an optimum. But if we must protest, because public vigilance through civil society action, individual action, and non-state agencies, actors, is also an important cog in the drive for accountability. If we must protest, then the government's response must not be to crush it. And the citizens who protest must also not be captured as to drive a political narrative. So the solution is, how can we ensure that the first four pillars operate at an optimum? Then you could have a whole year without having people pour on the streets.
Okay.
One would argue that what we find ourselves in this space today because the implementation of the Constitution has not been done as expected, because now we talk about all the other four limbs that need to work together in order for us to realize the constitutionalism and the respect of human rights as espoused by the Constitution, but that all these bodies seem not to be doing that, which then brings the question of political goodwill in ensuring that we achieve that which the Constitution espouses. So then, what must we do for all these limbs to work together for us not to see the frequent protests that we see every day?
I think there are two broad interventions, the legal interventions and the extra-legal interventions. The extra-legal does not always mean illegal. extra-legal means mechanisms that you cannot pinpoint to, you cannot have a specific reference to in the law. But let me begin with these legal interventions before we discuss the extra-legal measures. Yeah, the starting point, because I've said the Constitution rests on 5 pillars. The first pillar is that public officials, stroke state officials, will take responsibility for the mandate that has been assigned to them. So there's no back passing, or the buck stops with someone. So the buck stops with that particular office. By design, if there's a problem of police brutality, the person to answer to that is the IG under Article 245. And it's not permitted by constitutional design to explain it away, because Article 245 says that authority that he exercises is not subject to any other direction or control. And you see Article 157 of the Constitution that donates the power to prosecute to the DPP. Again, it says the authority is only subject to the Constitution. So we have to understand that the first pillar rests through the internal offices created by the Constitution. These are the public officials. The problem with these public officials is the problem of co-option, homeboy mentality. You know, if I'm in public office and I come from Siaya County, and for purposes of demonstration, our very own Baba, the enigmatic Baba is the president, I am, because of that homeboy mentality, I am predisposed to be sympathetic to the governance challenges that he faces. And then I become a threat to that office that I hold. It's an internal threat, not external. But those people need to know that we can hold them accountable through existing mechanisms, including prosecution for those who commit offenses and removal proceedings through judicial interventions. Then you have these constitutional commissions. So are they operating at an optimal? No. But the way to encourage them to operate at an optimal is to ensure that we continuously audit what they do. And I think at this stage, the IG will answer a few questions on command responsibility, for instance. And if that questions are not properly answered, he could find himself in problems. The constitutional commissions, I believe that only the Kenyan National Commission on Human Rights is operating at an optimum. It's very brave in documenting instances of violation of rights. But we need to ask ourselves, Chapter 15 has listed a number of constitutional commissions. What is it that they do to contribute to good governance? NCAJ, for instance, the NCIC, the National Commission, the National Cohesion and Integration Commission. Other than just producing reports on the balance of the public, the ethnic composition of public service, what is it they're actually doing to deepen the mandate? NGEC, for instance, what is it doing to make all voices count? Because all these things boost confidence in public service. If they are not, you might be surprised to learn that your failure to spotlight the work of NGEC or the ombudsman could be the reason that people are on the streets. Because if the ombudsman, the Commission on Administration of Justice, and NGEC, for instance, which you always consider as peripheral commission, they're not peripheral because they're listed in the Constitution. If they're operating at an optimum, we probably would have better outcomes in terms of governance. The National Assembly, by design, is not intended to be captured by the executive. Because the executive cannot, the president cannot even dissolve parliament. Term of parliament is protected by the Constitution. And then the judiciary. Yes, there is need for collaborative greatness, because that is what lawyers call collaborative constitutionalism, that the interdependence between the judiciary and the executive is a necessary imperative. You can't work in isolation. But don't let that interdependence lead to control. So you must protect your independence, and the Kenyans must see that the judiciary is independent and not susceptible to executive manipulation or control. Then we can then trust the court process. Now, I cannot comment about public vigilance, because that is what we see daily. Yeah? So in terms of sanctions, in terms of the legal interventions, we audit. And the Constitution has inbuilt mechanisms for holding these offices to account. The executive can be held into account, and you saw Parliament constituting itself into a committee of good conduct, charging and prosecuting and removing the Deputy President, the Honorable Rigathi Gachagua, challenging his actions as being contrary to the Constitution. If that was done in good faith, if we saw the judiciary taking on the executive decisions and under judicial review and reversing some of their actions, Parliament rejecting some of these nominations, it would boost public confidence. If we saw the DPP prosecuting officers who are culpable, would not be in the streets. So legal interventions exist, and these people know. I think if they're not being implemented at an optimum, I could only explain it in the context of homeboy mentality or some kind of external patronage. The kind of patronage that you cannot litigate and you cannot legislate. Because if you have an independent office like the IGP and he chooses to pander to the executive, then you cannot control that.
But Wakili, you've talked about all these guardrails. On paper, it looks good. The reason why we actually have a new constitution is we were then agitating for having a democratic space, having human rights, and all these other niceties. But it almost feels like we are going back to those days again, despite having a very good document that protects all of us. Now, when we talk about the executive, we look at the legislature. We've had these conversations here with MPs who are saying the parliament has been captured. We look at the judiciary. I don't remember a time when we had so much focus and scrutiny on the judiciary like today, because of all these arguments that even the judiciary is also captured by the executive. We talk about these independent institutions. We just talked about IPOA this morning and all these other independent institutions. And they're sort of like toothless bulldogs. They are crippled to the core because of the influence of the executive. Still goes back to the first guardrail. We go back to the executive. Now, when we look at the security agencies weaponizing public order laws to criminalize constitutional rights in this case, what then are we left to do? Because at the tail end is the common mwananchi, is the civil society groups, and the Wanjikos. What then do we do? Because ultimately, the protest is the only way to push back.
Then the protest will continue ad infinitum, because it's a part of our constitutional design for public accountability. If these other four limbs of these four pillars are not operating at an optimum, then public vigilance will persist. Public vigilance is not supposed to be muted. So it's a good thing, look, and it's not something to be depressed about. Mm-hmm. Look at the headline today. This is the kind of headlines that we see from the Standard we should be running continuously, because they speak of independent media. If you mute this voice, then you run the risk of compromising critical voices. If you take protests away from the streets, you run the risk, and the other four limbs are not working at an optimum, you run the risk of reversing or rolling back the gains that you've made since 2010. But there is the other extra legal measures. Mm-hmm. You talked about political goodwill. There are aspects of our governance architecture that does not depend on the formal law or proclaimed law. The idea that the Constitution, as they say, is that law that seeks to define, distribute, and constrain the use of state power, so that power can be applied to the intentions for which it was invented, and in the manner in which it was intended, to the purposes for which it was invented, mm-hmm. and in the manner in which it was intended. Now, the whole rubric of this, our governance architecture, rests on the rule of law. The rule of law is like a three-legged stool. The first leg is equality before the law. No one is to be deemed or to be considered to be above the law. The second limb is certainty of the law. Proclaim the law in advance so people can organize their affairs in compliance. So there's no trial by ambush. The third one, which we fail at terribly, is justifiability. State actors justifying their actions as having been founded in the law. Compromises on the rule of law can be addressed through legal interventions. What cannot be addressed through legal intervention is this and require extra legal measures is goodwill. Now, the Constitution presupposes that superstructure, the transformative superstructure, will be implemented in the context of a marching culture of compliance.
Which we don't have.
Culture cannot be legislated. Culture cannot be litigated. But there is something you can do about it. You can begin to deepen a conversation that pushes us towards constitutional morality. Constitutional morality is an extra-legal conversation because when you start talking about morality, you're talking about things that cannot be reduced into law. A sense of goodness, a sense of wrong, right and wrong. Here,
a sense of empathy.
Yes. Here, now there are two limbs here. When you want to deepen constitutional morality, you have to look at mutual tolerance and forbearance. Mutual tolerance is what I think is lacking. I'm just breaking down political goodwill, yeah? Mutual tolerance means that political leaders consider each other as opponents who disagree on what is good for the nation, not as enemies that ought to be crushed. You get? Forbearance, on the other hand, means that political leaders do not exercise the full extent of their powers just because they can. Remember, the political opposition has what you may consider as content power, the power to mobilize supporters to push a particular narrative. So they can infiltrate protests. That can also happen.
Like what we've just seen.
Yes,
yeah, we've seen that.
So they can infiltrate protests, and that infiltration, I can tell you, cannot be investigated and be prosecuted. Forget about it. I'm a lawyer and I'm living the practice in the law.
Why?
Because since I have a right as a political leader to encourage my supporters to join the protest and protest, I can ensure that if I belong to the political opposition, as many of my supporters as possible join the good cause. And that is not illegal. You get? So the design of building a hygiene constitutional morality is that whereas I know, like for instance, now the new political arrangements, the likes of Eugene Wamalwa, Kalonzo Musyoka, Martha Karua, whereas they can mobilize the political basis to hijack protests, they should not do so. Hijacking, I'm using that word liberally, meaning you can have more than 500,000 people on the streets demanding justice for Albert Ojwang. But if you look at the composition of these 500,000 people, 450,000 have been mobilized by supporters. I'm saying that is not unconstitutional.
Can you characterize mobilizing?
Mobilizing basically just means sending out word saying, please, look, we see a section of civil society driving a good agenda of accountability. Good. We need to know the circumstances under which Albert Ojwang died in police custody. And we have a right to protest. We want you to join that protest. Now we are saying, since the national government or the executive has intelligence, if they have access to which they cannot publish or make public, if they have access to intelligence that the political opposition is exploiting, and exploiting not in a bad context, taking advantage of this, or taking the opportunity, let me use that word, taking the opportunity of protest to pour in their supporters as part of piling pressure on the executive to achieve a particular political agenda, then you will see the kind of reaction. Now that is what we call political hardball. You will see the kind of reaction from the executive that is also difficult to contain. That reaction is what you now may consider as the constitutional hardball, because the executive will tell you, we have the power, we have the mandate to protect businesses. And therefore, police officers will come to the streets already conditioned to look out for protesters who may be disruptive. You get? So then you have a stalemate there. That's why protests sometimes end up in a bloodbath. Because this other side of not and not hijacking protests, so that we leave protest to achieve their constitutional objective of pressuring government do the right thing. If you understand as political leaders that you build a system of mutual tolerance, where you don't look at the political opposition as an enemy that deserves to be crushed, and the political opposition don't look at the ruling administration as someone who stands in the way of accessing power, then you can it's easy to have protests or to have accountability that is fairly consistent with democratic ideals.
Wakili, I need to ask you though, because here we are and we're seeing that protests we know are the right to protest is guaranteed.
Yes.
Right? And here we have the infiltration of these protests by criminals. We can dress it up, call it goon, whatever, criminals.
Yes.
Because you put lipstick on a pig, it's still a pig, right? Who infiltrate this. And we also know that the business of conflict is not cheap, neither is it free. That usually there is somebody who has paid the infiltrators. Usually that has happened and has facilitated that to happen. And then we see wanton destruction, we see wanton criminality, we see violence as a result of this, because I think time and again it has been proven that protesters with their agenda are not in the business of causing violence. They're not in the business of anything aside from the agenda, which is to protest against those things that you talk about, because those four are not optimally operational. So that's why we protest, right?
Yes.
Now, with the infiltration of this criminality, am I hearing you right when you say that cannot then be prosecuted and or interrogated?
No, that part can be prosecuted. There is the infiltration of protests by goons to the extent that they commit cognizable offenses. Then those can be investigated and prosecuted. In fact, Justice Jairus Nga, on 31st of December, in a case filed by a section of the civil society, found the Inspector General of Police, at that time Japheth Kome, to be responsible for the injuries meted against KPMDU officials. That guy with the complex names, one of those leaders that I'm forgetting is Davji Atela. Yes, he was beaten by police officers.
Badly so.
Badly so.
Yes.
So the High Court said, look, under Article 245, the command responsibility is on the IG. So the IG must demonstrate two things, and at that time the IG had not demonstrated those two elements, which I can tell you they have now done cleverly. At that time, the court found that there must be a directive that is unconstitutional. Number two, the action by the police officers ought to have been punished. The failure or the directive that is unconstitutional and the failure to punish actions by police officers was then deemed to have been sanctioned by the IG. And the IG Kome at that time was then held responsible. In this protest, what has changed is this. These protests are being led by the civil society, happening organically, and I've said the civil society includes active citizens, and there is no express directive prohibiting protests, because I've said the police have no business prohibiting protests. So they have cleared the first limb. The second limb is for police officers who are supposed to provide security, who then violate the law by attacking protesters, using excessive force to respond to protesters. Those officers must be interdicted, investigated, arrested and arraigned. You have seen the IG moving with speed. You may not know, but I suspect that is in compliance with the judgment issued by the High Court to avoid the IG from being found culpable or personally responsible for the actions of his juniors.
Command responsibility.
The command responsibility. So he has deflected it carefully, because right now it's not possible to hold IG, the present IG, under the command responsibility. He will say, look, I have not outlawed the protests, and my officers who violated the law, we are investigating them. IPO is investigating them, but internally we have interdicted them. Now, for goons who are seen wielding clubs in the CBD, I think if the IG wants to be on the safer side, he must order immediate investigation and arrest, because some of them are identifiable from the CCTVs. It's a dangerous trend that you have people on the streets who, according to witness accounts, seemingly enjoy police protection. If those people are not arrested and arraigned in court, the IG will be held accountable. So yes, there is that aspect of accountability that the law anticipates. The aspect that I'm saying that the law does not anticipate and the law cannot anticipate is, if I see you and I mean the four of us here, if we see that some youth are mobilizing to protest next week on Tuesday, and we say, you know what, this time round, I want to join them. Or if you call me, Dennis, and say, Wakili, I have not seen you in this protest. Would you mind joining us next week? And then I say I can. So the fact that you've mobilized me or reached out to me and I joined the street, if you can mobilize me and maybe 10,000 others or 500,000 others, that mobilization cannot be punished by the law. And I'm saying the political leadership, particularly the political opposition, have the potential, because you can't be a political leader unless you have political support. They have the potential of mobilizing their supporters to pour into the street. We are saying we urge restraint. Let protests happen organically. Let them not be hijacked or overtaken by supporters of politicians who are only there because they have been sent there
to disrupt.
Okay, I have a last question very quickly. Let's talk about self-defense.
Yes.
I'm looking at the Penal Code, Cap 63, Section 17, that talks about self-defense. And it says, permits use of force in self-defense, provided that it's reasonable and proportionate to the threat. Section 277, defense now of property, which now ties into what the business community is saying, allows reasonable force to prevent a felony, including theft or robbery. Now, with what we saw on Tuesday, hooligans coming into the CBD with weapons, do the protesters who feel, I want to go protest, but I also need to carry something, just in case I'm attacked, I will defend myself proportionate to the threat?
Then don't go. Short answer. You are not allowed as a protester to be armed.
Yeah.
Peaceful, unarmed protest, that is what the Constitution has sanctioned. Business owners, do not take measures or matters into your own hands by going through extra-legal interventions to act preemptively. To say, I'm going to open my business, if protesters come, I have hired my own goons. Because you run the risk, because the police have a duty to provide security. So if you are not sure about the level of security arrangement made by the police, then you can, and it's very depressing to see business people closing their businesses, losing income because there's no assurance of police protection. Protest must happen when businesses are open.
But if I go as a protester, let's assume I don't have a weapon.
Yes.
I'm a protester. You're a hooligan. Okay, you're not a hooligan.
Yes,
but for purposes of this discussion.
Yes.
So I'm coming to protest. I'm lifting my placard.
Yes.
And I'm protesting. Then you approach me with a baton, you want to beat me up. And I fight you back. I restrain you. Restrain you. Am I still within my rights of self-defense proportionate to the threat?
The short answer is no. Self-defense does not work that way.
Okay.
This is how self-defense works in criminal law. You must have been cornered that reacting is the only logical option. You know, we are in a closed room. There is no way I can exit through that glass door without smashing it. If I'm being attacked from the only exit, the question of this property doesn't arise. Or if I can't exit and you're attacking me, then I have to push you back using reasonable force. So you do not anticipate self-defense. And if you are ambushed, the first reaction is to walk away.
Or run away.
Right? Run away. You do not taunt the hooligans back. Because now, you cannot demand what you cannot give. You cannot demand protection when you're making yourself susceptible to attack. Equally, the police officers cannot go out with a predetermined agenda to violently disrupt the the United Nations basic guidelines on use of force during protests are very clear. And police officers have been trained on this. When I worked at ICJ, we trained officers on this. Yeah, use force that is proportional. There are 5 principles: proportionality, legality, precaution, and accountability. Ask yourself, in short, whatever you are doing, how you are reacting,
is it within the
law? Do you have a chance to run away? If you're cornered, you can't run away, then of course now you can fight back.
This has been great to be able to hear some of these things. We've never heard them before. And I think as we go into the season, it's necessary for us to continue to have these conversations. Steve Ogolla, we want to thank you for being first time in the hot seat, and definitely some nuggets that we can walk away with today, parts of this conversation. At 10:01, thank you for being part of Kenya's biggest conversation this morning. The Situation Room on this Justice Thursday is how we close the show. Thank you so much, and we join again tomorrow.
This is the Situation Room, the only way to start your day.